Hey there, and welcome to another episode of Living in Lansing, Michigan, your resource for everything you need to know about buying a home, selling a home, or living in the greater Lansing area. I'm Brooks Warner, and your host and local real estate agent at Mitten Home Team at Keller Williams Realty. Today, I have a special guest coming in, a good friend of mine, Dave Williams, who is an estate planning attorney, and he is going to be sharing very important information about estate planning and everything that goes into it. Before we get started, don't forget to like, subscribe, and turn on notifications to see future videos, because this is probably going to be a mini series with a couple different videos, as there is a lot to cover. This is a topic that's really hit me near and dear recently, as I've been dealing with it quite a bit, both personally and professionally, and there is a lot to know when it comes to estate planning. This is going to be a real hot topic over the next few years to a decade, as the baby boomers are continuing to age and leave their estates to their heirs. So let's go ahead and get started. Also, I almost forgot, if you have any questions related to this topic, go ahead and drop them in the comments. I'll make sure they get answered for you, or always feel free to email me, brooks@mittenhometeam.com. I answer questions like this all the time, and if I can't answer them, I'll get you in touch with David so he can help you out. All right, I'm here with my friend, an estate planning attorney, David Williams, and he's gonna help give us a little bit of information that we feel like everyone needs to know when it comes to planning their estate. Thanks for coming, David.
Yeah, thank you. Thanks for having me.
So I guess it's really up to you where we start this, but I was kind of thinking you have a couple different options when it comes to estate planning. And one option, well, it's probably not a great option, is to do nothing and let your estate go through probate, is what would happen at that point, I believe, right?
Right.
So do you want to start by talking a little bit about what probate is and what that would mean for heirs if everything had to go through probate?
Yeah, I think that makes sense. Starting with what I always like to tell people is everybody has an estate plan. Even if you didn't make one with an attorney, if you didn't draw up a will or a trust, you have an estate plan, and it's what the state says it is. And it's not always what you think. So
Okay.
if you're a homeowner and you pass away and you don't have a will or a trust, things we call an estate plan, what happens? So your heirs, whoever they are, possibly your spouse, maybe your children, depending on your family situation, they would need to go to probate court and determine who's the person responsible for managing the estate. In Michigan, we call that personal representative. Most states, a lot of people call that executor. That's what most people are familiar with. But that person has to go to court and get permission to handle things for you.
Obviously, it's probably different in every case, but how do they determine, say, we can use me as an example, even though it's a little bit grim and my kids are little. If I pass away tomorrow, well, we won't say tomorrow. We'll say that my kids are of age. I pass away and I have nothing in place. How do they determine which one of my kids would be my personal representative?
Well, if both of your kids are adults, they have equal priority.
Okay.
So if they get along, they could agree amongst themselves and select which one's going to do it. If they don't get along, now we're stuck with the judge determining which one is suitable or best suited to do that.
Okay.
If either of them, and if they just flat out don't get along, the judge might pick a third party.
Okay. And then that would be the same whether you had 2 kids or 10 kids.
It would
kind of
be-
works the same, right?
It would be the same, but much worse,
Yeah.
possibly, right? You got
Yeah.
10 people vying for the same job.
And one thing I can tell you from a professional standpoint, helping families that are dealing with this, even if you think that people are going to get along, oftentimes, unfortunately, once money's involved, they get along not as good as they did before money was involved. Let's
Right.
phrase it that way. So how about timeline? Let's talk about, I pass away today and I have nothing in place and my heirs have to go through probate. What's kind of the timeline to resolve that?
So probate estate in Michigan has to be open for at least 5 months.
Okay.
That doesn't mean that they have to wait 5 months to sell your house. But the timeline, if everybody gets along, we can usually get a probate estate opened in a week.
Okay.
If they don't get along, and we're in the, I didn't make a will plan.
Right.
So if you don't have a will and everybody gets along, we can do informal probate and get a probate estate open relatively quickly.
Okay.
If folks aren't getting along, then we have to have a hearing, and that can take a month or two depending on the county the backlog before we have a hearing, and then we get the estate up and running. But that's when things really start to bog down.
So does that mean in that initial time period, whether it's a week or a month or two for a hearing, that assets can't be sold and the heirs don't have access to them?
Correct.
All right, so say that someone passes away, their stuff has to go through probate, and their heirs are trying to plan a funeral and burial. Are they kind of on the hook to cover that in the meantime? Can they use money before probate is settled for things like that?
So that's going to depend. It's going to depend on several things. A lot of people will do sort of a do-it-yourself estate plan where they add one of their kids or a trusted family member as a joint account holder.
Okay.
If they've got a joint account holder, that person still has access to the bank account. Some banks will allow you, if you show I'm an heir, so I'm an adult child or other relative of the deceased person. If you say that and you take a death certificate with you and then all of the funeral bills, they might release the money, but that's up to the bank's policies.
Okay.
And then in most instances, what's going to happen is the bank's going to say, come back with your letters of authority, showing that you've opened a probate estate and you are the person that we're allowed to release this money to. So most of the time, we're going to have to wait for a probate estate to be open, and the kids are going to be chipping in money, hopefully all of them equally, not always, to pay for those, because that has to happen within a relatively short time.
Yeah. Okay. I think that answers that question. What else do you think, if someone who you were really personally close with was sitting here and you were telling them the pros and cons related to not having an estate plan and using the state's estate plan, which is essentially the probate process, what would you want them to know?
Well, I'd say, first of all, everybody's situation is unique. So it's going to ultimately depend on that person's situation, of course. But in general, I'd say there's probably no pros to not having a plan. If you have a plan in place, we can provide, you can make the decisions for who's going to be the personal representative. If you've got in Brooks's case, 2 adult children, hypothetically, yeah, or 10, you can say, this is the one that I want to manage my estate. Now, the probate estate can go much faster. We don't have to get people to agree on it. So that can help things move along.
Okay.
So I think the pros are on the side of making a plan,
okay,
versus not doing anything.
Okay. Well, then let's maybe talk about the next plan option. So if I understand this correctly from my experience talking with you and work in general, you kind of have probate is no plan. A little bit of a plan would be a will, and then beyond that is trust and probably some other stuff that I don't know about. Is that accurate?
Yeah.
All right, then let's talk about will next. So maybe you don't have a whole lot of estate, so you think that you just need a will. Maybe my first question is, how do you know if the will is the right tool for you or if you need a trust?
Well, it's going to ultimately depend on your situation, again, and it's going to depend on what assets you own.
Okay.
So when we meet with clients, before we have that initial estate planning meeting, we'll send out questionnaires asking them about who their family members are, what are their ages, where do they live, those normal kind of things. We'll also ask them about their assets. If they own real estate would be a probate asset if we don't make a plan. So we're going to ask about that as well. And then when we sit down, we're going to say, talk to them, what are your plans? How do you want this to play out?
I'm going to interrupt you and back up a little bit.
Yeah.
So you said real estate is a probate asset. So what are probate assets and what are not probate assets?
Yeah, so what I'd like to say is talk about who inherits stuff from you and in what order. So the first thing that's going to control who inherits your asset is going to be joint title.
Okay.
So if you're married and the deed says Mr. Smith and Mrs. Smith, husband and wife, own the property.
Yeah.
If Mr. Smith dies, it just belongs to Mrs. Smith, because they're husband and wife.
That makes sense.
So it's going to be dependent on how things are titled. Or if the bank account says Mr. Smith and his adult child are joint owners, that account's not going through probate.
Gotcha. Okay.
The other thing too, and there's a lot of nuances,
Yeah.
would be beneficiary designation. So if you're a client, you come to me, you rent an apartment, and you have an IRA and a bank account and a car and one child, you might not need to do a whole lot of planning. I still think everybody needs a will, but beneficiary designations would also pass outside of probate.
Gotcha. So you could add your kids as a beneficiary on your bank accounts, retirement accounts, and then theoretically circumvent the probate process.
Correct.
Essentially that
Yes.
way. Okay.
Yep.
All right. Sorry, I kind of interrupted you. Let's jump back into wills now.
Yep.
You said something that made me think of a question I thought was good to ask. So.
It's a good question.
Yeah. So, like, how do you know that the will is the right tool, and what are the limitations of a will, basically?
Yeah, so wills still go through probate,
Okay.
but they get to settle those things that a court would otherwise have to determine. So if you have the hypothetical 10 children, your will can say, this is the one that I want to manage my estate.
Okay.
And if you want everything to go to the 10 of them equally, the will can say that. Or
Okay.
it can say, I want this item to go to this child, I want this item to go to that child, and split everything else up a certain way. So you,
Okay.
with the will, you get to decide. We're not left in what the state says. You get to make the decisions on who gets your stuff and in what amounts.
So then where does probate come into the will piece? If I have a will and I have child A is helping divvy everything up because that's how I set my will up, then what's the purpose of probate, or how does it have to go through probate?
Yeah, so probate is just the government system for orderly administration of estates.
Okay.
And if you pass away and you own something in your name and you have a will, so if in Brooks's example, your will names child A as the personal representative, now child A can just go to the probate court and open up the estate and say, I have priority. I don't have to get renunciations or waivers from the other 9 children.
Oh, okay.
I'm the one that can open the estate, and there should be less delay.
Gotcha.
Hopefully no delay when you've already made that decision.
Okay, that makes sense. So essentially it's taken out the who makes the decision pieces
Yes.
of it by having the will.
Yep, that's part of it. And then the other part is who gets what. We're not left with what the state says. We're left with what you decided. And honestly, most parents are going to say, give it to my kids equally.
Right.
But not always. Not all kids are the same.
Yeah. So, in the event you have a will, child A is named personal beneficiary or personal representative rather. Does probate have to approve the sale of assets and things like that, or how does that work?
So probate does not have to.
Okay.
If we're doing informal, unsupervised probate, which most wills are going to say, I do not require a judge to approve everything that the
Okay.
personal rep does. They don't need approval before they sell the house.
Okay. So a will set up right would help alleviate all
Yeah.
of that. Set up right is probably the key phrase there, because it could also probably not. I've seen some that are not done very well.
Yes, I've seen wills that people have downloaded off the internet, and
Yeah.
everything ended up going to the state. So.
Okay. So that kind of cover anything else that you think people should know about wills or their limitations or what they're a good tool for? Pros and cons, kind of.
Yeah, I think everybody needs a will, even if we're doing a trust, because you get to make the decisions. We're not going to leave it to a probate court on which person manages things. So I still think that it's a useful tool. If we have that client where everything is beneficiary designated, a will can still be a useful tool just in case. There's a account they forgot about, or things like that. So I like to have the will. A lot of times with a will, we would couple that with a ladybird deed. And if I'm getting ahead of you, let me know.
No, that's fine.
So-
I love ladybird deeds. I think it's one of the most underutilized tools in real estate,
Yeah,
honestly.
it's a
Like,
very good tool. And the benefit of the ladybird deed, or one of the benefits, is it avoids probate. So maybe we don't have an estate where we feel like we need a trust. We have 2 kids like Brooks, and we say we just want everything to go to them. when I pass away and I want to avoid probate. So if I've got an IRA, a bank account, a house, and a car. Well, the house is the one asset that would normally have to go through probate. Your bank account can have beneficiaries, the IRA can have beneficiaries, cars can avoid probate if we're not opening a probate estate. So what do we do with that house if we have a relatively simple estate?
Okay.
Ladybird deed can be a good option.
For those who don't know what a ladybird deed is, what is it and how does it work?
So a ladybird deed that's a common name for what we call an enhanced life estate deed. So Brooks, if you wanted to make a ladybird deed, he can make a deed that says Brooks conveys his property to himself for his lifetime. And he retains the right to sell it, do whatever he wants with it, but if he owns it when he passes away, it automatically transfers to these people. So if you passed away and you had a ladybird deed and your daughters took the death certificate to the Register of Deeds, automatically that house becomes theirs. So,
seems easy.
Yeah, it can be very easy, and
Okay.
it can also be complicated, which you might want to ask about pros and cons.
Okay, yeah. So sounds like it's easy. It can be complicated. What's the pros and cons of a ladybird deed?
So I think the pros, there's a lot of pros. One of the main ones we've already touched on, it avoids probate. A second pro is it can help with Medicaid planning. So if you're a senior adult and you're concerned that you might need long-term care and might qualify for Medicaid, if we don't do a ladybird deed and your house goes through an estate, the state can recover from your probate estate when it sells your house. So if it doesn't go through probate, there's no estate recovery, your heirs get to inherit the house.
So if I understand you correctly, theoretically, no ladybird deed, you go on Medicaid, the state could say, well, the estate owes me this. That's a lot of states. The state of Michigan essentially could say that the estate owes us X number of dollars because of Medicaid when this asset's sold.
Right. Yep. They put a lien on the house.
Okay.
And say we advance this much for person during their lifetime for medical care or for long-term care. Therefore, when the house sells, we're getting paid back first. And first might be overstating it. Funeral burial gets paid.
Okay.
Expenses of administrating the estate gets paid.
And I assume any other, like a mortgage would still.
A mortgage would still get paid if it's a priority lien.
Yeah, okay.
Yep. And then other cons potentially, of a ladybird deed.
Yeah.
Would be, I said other cons, we only talked about pros. So one of the cons of a ladybird deed would be if we have too many kids, which is a good problem. Maybe it's not a problem, it's a blessing. But if we have so many kids, now we all of a sudden have 3, 4 owners of a house, and all of them have rights in that house, that
Right.
property, and they all have to agree on which realtor to hire, if they're gonna sell it, what offer to accept. So now Brooks or your realtor is working with 3 or 4 or 5 people. So yeah,
Which makes the more people you add, the more difficult every situation gets, right?
correct. So some people will decide to just leave the house as a probate asset, so their one personal representative manages it, or we might do a trust.
Okay. Well, I think that kind of segues us into what's a trust, and I know this one can be pretty complex, so maybe we'll take a quick break and we'll make a second video about what is a trust and the pros and cons of that. Sound
Okay,
good?
Sounds great.
So remember, like, subscribe, turn on your notifications so you see the future videos. Also, if you have any questions, drop them in the comments. I'll make sure that they get answered. If I can't answer it, I'll get you connected with David so he can answer your questions for you. Thanks so much for watching, and stay tuned for the next video.